Hi, I'm Sean Flaherty. I'm an IP partner at GRSM. Today, I want to talk about online IP enforcement. Consider you're coming up with a new product or a new offer. Let's connect at that point, because this is one of these instances where an ounce of prevention is a pound of cure. We can file for trademarks and copyrights when you're coming up with your name, any of the creative aspects of your product offering, the labels, the photos, videos, ads, scripts. If we can file trademarks for those brands, or if we can file copyrights for those creative assets, then you're going to be in a really good spot to go ahead and market, protect that product or offering you're coming up with. The benefit of filing for a trademark or a copyright is that it gives the public notice that you own those assets, you own that brand, or you own that creative material. And if you have to bring an enforcement proceeding, say a lawsuit, you might be entitled to enhanced damages. This is why we want to get the wheels in motion before you launch, because the trademark laws let us apply for a trademark application before you start using it or branding your product. And likewise, the Copyright Act lets us apply for copyright protection before you've actually published your creative asset. Don't panic if you've already launched your brand. There are tools to expedite the process for applying for trademark and copyright applications, especially if the basis for that is because somebody else is infringing or copying your work. Regardless, now you're up and running and you learn that somebody's knocking off your brand. What do you do then? If we can identify the bad actor, we can reach out informally. We can send them a letter. We can demand that they take this stuff down, and we can demand that they pay you money. If we can't identify the bad actor, perhaps they're foreign or under a bunch of shell companies where you can't figure out who the entity or the operator is, we can submit a takedown to the platform or online hosting provider, and that may be enough to remove or disable the infringing offer or product. And if neither of those work, we can file a lawsuit. A lawsuit starts the proceedings in which you require a defendant to show up in court, respond to your demand, and fight it out. At the end of the day, you're asking for an injunction from a judge. The injunction says that they have to stop their infringing activity, and then also damages. And damages can take many forms, some of which might include demonstrating your entitlement to profits that you've lost, those sales they've taken from you, or even clawing back the profits that they've gained by riding your coattails and using your work. If you're dealing with any of these issues, make sure to reach out. I'd be happy to connect. Thanks so much for your time.